Good day, everyone. Welcome back to another episode of The Law and You. Today, I intend to focus on parliamentary supremacy as continuing from our previous episode, but I will look more at parliamentary privileges. Now, the separation of powers doctrine has contributed to the development of the law of parliamentary privileges. Essentially, Parliament has certain important privileges to primarily protect it from outside interference. These are necessary to ensure the efficient operation of Parliament as the primary lawmaking body of Guyana. Now, one important privilege enjoyed by Caribbean parliaments is the power to control its own affairs and proceedings. Specifically, Article 165 of the Constitution of the Cooperative Republic of Guyana, it states that the National Assembly may regulate its own procedure and may make rules for that purpose. Now, this privilege precludes the courts from intervening in the internal proceedings of Parliament only where there is a breach of the Constitution. As opined more clearly by the trial judge in the case of Hughes and Rogers, it was stated that alleged irregularities in the conduct of parliamentary business are a matter for Parliament alone. Now, you may wonder why this is so, but this is important for the smooth working of a democratic society that has a separation of powers between an legislative parliament, an executive government, and an independent judiciary. So the courts have to respect the separate functions of each organ, and even where there may be a breach of an internal control in Parliament, the court cannot intervene with those procedures. Another privilege afforded to Parliament is the ability to delegate its own powers, as well as the consequent obligation to then maintain effective control of these powers that it delegates. So, ordinarily, while the power to make laws is constitutionally vested in Parliament, Caribbean constitutional law allows for the voluntary redistribution by Parliament of these powers. The Chief Justice, in the case of Astafan versus Control of Customs, recognized that the delegation of the legislative powers by the legislature to the executive is not inconsistent with the principle of separation of powers, so long as the legislature retains effective control of its powers. So you may wonder how effective control is maintained by Parliament, and essentially the legislature has to put certain limits in place on the powers that it delegates, as well as establish guidelines for the use of these powers by the executive. Again, the Caribbean courts have a duty to strike down any administrative or executive decisions that exceed the jurisdiction of the legislature or undermines the authority of the legislature. So in plain language, delegated legislation as made by the executive, it cannot amend or otherwise conflict with any parent act or any parent legislation as made by Parliament. Now, in addition to the executive, the legislature can also delegate powers to the judiciary or to judges who usually establish various procedures and rules of court. So, the power to delegate legislative authority, whether to the executive or the judiciary, it's justified as being necessary and it promotes constitutional efficacy. Moving along, I will now address how judicial review of legislation by the courts is permitted with limits. Now, as I previously alluded, superior courts have the power and the duty to review legislation as made by Parliament that is not in conformity with the Constitution. And this stems from the principle that the Constitution of Guyana is the supreme law of the land. Nevertheless, there is this power of the superior courts to review the laws made by Parliament, but they do not have an unrestrained power to interfere with the powers of Parliament. So essentially, Parliament is privileged in that the power of review has its limits as well. As stated in the case of the Bahamas Methodist Church versus Simonet, Lord Nichols explained that the courts can declare legislation as inconsistent with the Constitution, applying the principle of constitutional supremacy. However, the courts are to administer acts of Parliament, not to question them. Then the final point I will address today is concerning the incorporation of international treaties into domestic legislation. Now, ordinarily, ratified treaties impose international obligations on the countries, but they are not binding on domestic law unless they are incorporated by the legislature. Now, this is effective through the enactment of legislation by Parliament. So essentially, while the executive is responsible for entering into, ratifying these international treaties, Parliament or the legislature is actually afforded the privilege of enforcing such international treaties. So to recap, Parliament has the following powers and privileges. Firstly, Parliament has the power to control its internal affairs. It also has the power to delegate its powers, but it must maintain effective control of these powers that it delegates, whether to the executive or to the judiciary. Parliament can also have its decisions reviewed, but only where they are in contravention with the Constitution as the supreme law of the land. And lastly, as I briefly discussed, Parliament has the power to incorporate international treaties into domestic law. So, considering all that I would have said, it is prudent to note that without such powers and privileges, Parliament would not be able to effectively and efficiently execute its powers as afforded by the Constitution, which is to make laws for Guyana. So, if these privileges were not in place, then Parliament would not be able to function as the primary lawmaking body of Guyana. That brings me to the end of today's short presentation. Until next time, thank you for your time and attention. Audio Jungle.